Hi everyone. Today we will discuss Chapter 10. In Chapter 10, the focus here is on the access to health information. All right, so let's go ahead and get started. So, as a brief introduction, access to patient-specific health information is complex, and it's an issue that's governed by a variety of legal rules. Healthcare providers are charged under law with obligations to maintain patient-specific health information in a confidential manner. At the same time, providers are charged with the obligation to allow third parties and patients access to patient-specific health information if appropriately requested. The law particularly targets disclosure of patient-specific health information that is deemed confidential. Confidential information is distinguished from non-confidential information by the fact that the information is made available by the patient to the healthcare provider during the course of their confidential relationship. Non-confidential information is generally considered information that is a matter of common knowledge with no restrictions requested by the patient. Questions of access to and disclosure of patient-specific information frequently arise in the healthcare context. For that reason, the HIM professional must understand the legal principles that govern ownership and disclosure of health information, and how disclosure principles differ with respect to who seeks access to the health information and when disclosure of health information is mandated by law. With the knowledge and understanding, the health information manager can develop and implement policies and procedures that address access and disclosure of patient-specific information. So who really owns health information? Is it the patient? Is it the provider? Is it both? Can health information truly be owned as opposed to owning the medium in which the information is stored? At this time, the law is in transition. It provides no certain answer to questions of ownership of health information and the media in which it is stored. Traditionally, the law has focused on the medium that has been used, the paper-based health record. Under the traditional approach, the health record was considered the sole property of the healthcare provider, and the patient-specific health information was not considered separate from the medium used. Decisions on whether to allow access to the health record fell within the sole province of the healthcare provider. The provider reached decisions on access through the guidance of the provider's professional association, and if the association's recommendations was to prohibit access to the patient and the healthcare provider did not believe otherwise, so be it. As privacy rules were established and defined by courts and patient awareness grew, the concept of the patient possessing a right to his or her own health information contained in the health record developed. Over time, the trend has moved away from focusing on the medium used and more towards the protection of health information itself. The trend manifested in the regulations that were issued in HIPAA. The HIPAA privacy rule recognizes clearly that the patient possesses a right of access to his or her own information. While HIPAA recognizes a patient's right of access, it does not go as far as specifying that the healthcare provider acts in a trust capacity for the patient. The idea of placing health information in a trust capacity is a trend of the future. Under this trend, healthcare provider acts as a trustee for the patient's benefit to create, receive, and protect patient-specific health information. Currently, the law has not caught up to this trend, leaving answers to question of ownership of health information to fall somewhere in the middle of the continuum. While the law has not kept pace, the trend of placing health information in trust has come to reality in part with the introduction of health record banks. Health record banks are repositories of personal health records in the electronic form that's operated by government or commercial entities who serve as trusted custodians of data contained in the health record bank. Data is added by the patient, caregiver, and others to the personal health record over the patient's lifetime. This data is fully accessible by the patient and available to others upon the patient's consent. One general rule of ownership, however, is accepted in virtually all of the U.S., that the health record as a medium is owned by the healthcare provider, with the patient possessing a right or interest in the health information contained in it. The general rule is established at the federal level through the HIPAA privacy rule and at the state level by statute, by licensing regulations, and by judicial decision. When determining ownership issues in any particular situation, the HIM professional must be conscious of this rule and review state law for guidance, including regulations governing specialized patient records. As was outlined in Chapter 8 previously, the health record serves multiple uses. In addition, it supports the care provided by the healthcare professional. Its use traditionally unknown to the patient, such as fundraising, marketing, are also involved. Federal statutes for the privacy of patient-specific health information, also known as the HIPAA privacy rule, dictate that a patient be notified of these uses and be given the opportunity to consent, reject, or request restriction of this information for any or all of the many uses of the health record serves. This notice requirement is commonly referred to as the Notice of Privacy Practices. The rule details both the content of the notice and the methods by which the patient is notified of the provider's information practices. A sample notice of information practices is illustrated in the textbook. In addition to receiving healthcare providers' notice of information practices, the privacy rule sets a standard where the healthcare provider may seek a general consent from the patient to use or disclose patient-specific health information to carry out treatment, payment, and healthcare operations. This consent is referred to as the consent to the use and disclosure of health information for treatment, payment, and healthcare operations. The privacy rule recognizes that patients may wish to restrict the uses and disclosure of their PHI and allows them to do so at the time of receipt of the consent document. The content requirements for a consent form in this context is also illustrated in the textbook. Overall, the content requirements for consent to use and disclose patient-specific health information to carry out treatment and payment of healthcare operations is below. It includes the consent must be in plain language, inform the individual that the information be used and disclosed to carry out treatment, payment, and healthcare operations. It refers the individual to the Notice of Information Practices. It informs the right to restrict, use, and disclose, and it informs the healthcare provider's option to not agree with restrictions. In addition, it must be signed and dated by the individual. The HIPAA privacy rule allows the option not to agree to request for restrictions. This includes the provider could condition treatment, the health plan could condition enrollment, and upon obtaining patient consent to use and disclose. In 2009, the American Recovery and Reinvestment Act came to be. In 2009, when this act was established, it modified the ability to honor or not honor patient requests for restriction, and it put regulations on compliance with restrictions that were issued by the Secretary for Health and Human Services. In addition to the requirements of the HIPAA privacy rule, states have decided to also take action. In the very recent past, Hawaii required healthcare providers to supply patients with a notice of confidentiality practices and authorizations in a manner similar to the HIPAA privacy rule. After determining that no widespread abuse of the privacy of health records existed in the state of Hawaii, the state repealed its law and relies solely on the HIPAA provisions. Montana and Washington are two other states that have adopted the Uniform Healthcare Information Act, specifying notice to the patient of confidentiality practices. In the future, other states may enact even more stringent provisions addressing the same question. Both the federal and state governments may pass laws, rules, and regulations that address the same matter. In such instances, health information managers and directors must determine how to reconcile federal and any state requirements. The first step in this reconciliation process is to address the question of preemption. Under the preemption doctrine, certain matters are of such a national as opposed to local nature the federal laws preempt or take precedence over state laws. HIM managers and directors should examine carefully the content of the federal law, rule, or regulation in question in order to determine to what extent it addresses preemption. Compliance with both the federal and state standards is the second step of the reconciliation process. Finally, if federal law does not preempt state laws, most stringent law is what governs in this case. Questions of access to health information by the patient or by third parties are on behalf of a patient are governed by a complex web of laws and regulations. To navigate through this web, HIM managers and directors must understand the general principles of disclosure of information. From there, professionals must then understand the differences the law makes between access by the patient and access by third-party payers. From the general ownership rule addressed earlier, flow two additional principles. The first, records remain within the provider's control and safekeeping and may be removed only in accordance with a court order or subpoena. And two, the provider may not disclose or withhold health information at will. Under the HIPAA privacy rule, a valid authorization must be in plain language and contain at least the following core elements: the individual's name, a specific and meaningful description of the information to be used or disclosed, the name or other specific identification of the person or class of persons authorized to make the disclosure, the name or other specific identification of the person to whom the disclosure is to be made, an expiration date or expiration event that relates to the individual or purpose of the use or disclosure, a statement of the individual's right to revoke the authorization in writing, exceptions to the right to revoke, together with how the individual may revoke the authorization, a statement that the information used or disclosed pursuant to the authorization may be subject to redisclosure and lose its protection status, the signature and date of the individual, and if the authorization is signed by a personal representative of the individual, a description of the representative's authority to act for the individual is warranted. A release of information may be considered invalid if it contains any of the following defects: the expiration date has passed or the expiration event is known by the covered entity to have occurred, the authorization has not been filled out completely with respect to an element described in the core elements section, the authorization is known by the covered entity to have been revoked, the authorization lacks an element required in the core elements section, the authorization violates the compound authorization requirements and/or material information found in the authorization is known by the healthcare provider to be false. What information may be released is also the subject of federal law. Introduced as part of the HIPAA privacy rule and reinforced with provisions of the American Recovery and Reinvestment Act of 2009, the principle of the minimum necessary standard governs the release of protected health information. The principle of the minimum necessary standard under both HIPAA and the ARRA requires that the healthcare provider make reasonable efforts to limit the patient's specific health information to a limited data set. A concept addressed later in this chapter, or to the minimum necessary to accomplish the intended purpose of such use, disclosure, or request, respectively. The healthcare provider must identify those who need access to the information to carry out their duties, what category of access is needed, and what conditions, if any, are appropriate to such access. Who may grant authority to the release health information is a matter that's governed by state law and regulation. Generally, the authority to release information rests with the patient if the patient is a competent adult or emancipated minor, a legal guardian or parent on behalf of a minor child, or the executor or administrator of an estate if the patient is deceased. The method of disclosure is also governed by professional guidelines and policy and may be by mail, electronics, transmittal, or by fax. One additional safeguard mandated in certain states is the inclusion of a redisclosure notice with the information that was sent. This redisclosure notice is a statement placing the recipient on notice that the information received may be used only for the stated purpose and that the recipient is barred from redisclosing the information to third parties without the patient's authorization, and the information should then be destroyed after the stated purpose is fulfilled. Although it may seem elementary that the health information contained in the health record does belong to the patient, and therefore the patient has a right to review and copy that information, that concept has only recently been established by the federal government pursuant to the HIPAA privacy rule. This rule grants an individual a right of access to inspect and obtain a copy of their PHI about their individual in a designated record set for as long as the PHI is maintained in the designated record set. If a covered entity under HIPAA uses or maintains the patient's PHI through an electronic health record, the American Recovery and Reinvestment Act of 2009 provides the patient with a right of access to his protected health information. The covered entity must then provide the patient with access to the PHI in the form and format that's requested by the patient if it is in a readily producible or if not in a readable hard copy from form or such other form or format agreed to by the patient and the covered entity. Let it be known that the covered entity may charge a fee for providing this service that's subject to limitations. The HIPAA privacy rule established a floor of patient rights and not a ceiling. States are free to provide even further rights of access by the patient to his own health information. The extent of the patient's access to his own health information is similar to the continuum of ownership issue, and it ranges from those states that do not address patient access at all or allow the healthcare provider to determine the extent of access to those that specifically grant patients access to their health record. Because each state law varies, health information managers develop policies on the release of information directly to the patient must review not only HIPAA privacy rule, but also applicable state law, particularly if the policy is to be developed for a hospital system that spans more than one state. Although patients have gained greater rights of access to their health information, the rights of access are not absolute. Under certain circumstances, the healthcare provider may be justified in withholding access to the health information from the patient. In addition to reviewing state law, the health information professional should also examine the terms of the HIPAA privacy rule for guidance on the time and manner of access granted to patients to review their own health information. One recent phenomenon that affects the patient's access to his own information is the advent of the personal health record. The PHR is a collection of a patient's important health information that can be drawn from multiple sources and that is managed, shared, and controlled by or primarily for the individuals. Patients may keep their own PHRs, or they may keep a PHR for another person, such as a child or parent for whom the person has responsibility. This phenomenon has grown as a direct result of the right of access to patients' own information that's recognized under HIPAA. The extent of access and the need for patient authorization is defined by the identity of the third party that seeks access. For example, if a party seeks access is the patient's attorney or the insurance company, the healthcare provider may disclose patient-specific health information only with the patient's authorization. Similarly, patient authorization is generally necessary before disclosure may be made to a federal, state, or local government agency. Another example of a third party requiring patient authorization is a member of the patient's family. Although a family member may believe he possesses an absolute right of access to patient's health information by virtue of a family relationship, that is not the case under the law. Third parties seeking access to PHI may offer to pay the healthcare provider for the information. Under provisions of the ARRA and HIPAA High-Tech Omnibus Final Rule, healthcare providers are prohibited from selling this information absent an individual's written authorization to do so. This provision eliminates the practice of aggregating patient data and selling it to third parties. There are exceptions to prohibition, which include public health activities, research activities, patient treatment, the sale, merger, consolidation with another entity, as well as business associates pursuant to an agreement. With the increasing demand for access to health information, the cost to healthcare providers to respond to such requests has increased proportionately in terms of both materials used and the employee time and labor. The law has recognized that the healthcare provider should not bear these costs free of charge for those requesting information access. State laws generally permit providers to charge reasonable fees for reproduction of the records. A reasonable fee is defined as a fee charged by the healthcare provider for the reproduction of the record. On federal level, rules enacted pursuant to HIPAA's High-Tech Omnibus Final Rule clearly state that a healthcare provider may impose a reasonable cost-based fee for reproducing the record. Central to the rapid advancement of healthcare is the role of medical research. Research studies have measured the overall impact, effectiveness, quality, outcome, and cost of occupational hazards, new pharmaceuticals, and the treatment methods of diseases and infectious illnesses. The result of this research have led to improved understanding and improved possibilities for the management and prevention of diseases and disabilities. There's a considerable volume of regulation that exists federally that govern research of human subjects, and this was not always the case. As we discussed in Chapter 5, the ethical standards, concepts such as autonomy, beneficence, justice, rights, and veracity are all central tenets of the healthcare world. When abusive research studies violate these concepts through such access as withholding information from patients, employing coercive or deceptive tactics, or taking advantage of a vulnerable population, people within and outside the healthcare world reacted with outrage. Ethical concepts and ethical concerns occupied the thought of many, and others focused their concerns upon developing means to establish and enforcing ethical protections at a legal level. The effort evolved into regulations of the research study industry. In 1978, the Belmont Report was formed. The Belmont Report was a group that published what many considered the landmark document in human subject research ethics. The Belmont Report asserted that there are three main principles form the ethical basis for all research involving human subjects. This includes the respect for individuals, benefits, and justice. Several requirements arose from each of these principles. For example, requirements for treating individuals as autonomous agents, obtaining informed consent, and respecting the privacy of research subjects derive from the principle of respect for individuals. Requirements for studies to seek a balance between benefits and risk to the patient, along with a strong research design that maximizes benefits and reduces harms, derive from the beneficence principle. Requirements to select subjects to equitably and avoid exploitation of vulnerable populations derive from the principle of justice. According to the authors of the Belmont Report, these principles carry equal force and weight and are used to evaluate the ethical nature of any research study that involves human subjects. The Belmont Report also provides the ethical basis for the federal regulations that govern research involving human subjects. These regulations require the review of all research involving human subjects by an institutional review board, the IRB, requires informed consent be obtained from human research subjects, and 3, an assurance by the institution that it will comply with these federal regulations. The Office for Human Research Protections, an agency within the Department of Health and Human Services, administers these regulations. Because human subjects are involved, confidentiality of patient information becomes critical. At the same time, the success of research depends in large measure on the access to health information about these subjects. The balance that has to be struck between these two competing interests has been answered on the federal level through the Department of Health and Human Services and the FDA, which promulgate regulations that govern the participation of human subjects in clinical investigations. The Department of Health and Human Services supervises investigators who receive the federal funds for research, and in turn, the FDA then supervises clinical trials of pharmaceuticals and related medical devices. The regulations that have been promulgated by each agency require investigators to obtain the approval of the Institutional Review Boards, the IRB, before involving any human subject. Typically associated with university and medical centers, the IRB is a group that's designated by an institution to safeguard the rights and welfare of human subjects by reviewing, approving, and monitoring medical research. The IRB relies on 3 ethical theories in its work: benefits, to do no harm, promote good; autonomy, respect for all individuals; and justice, for fairness. As part of the safeguards, the IRB requires the investigator to submit the research plan and informed consent form to the IRB for approval. The IRB reviews multiple elements of research plan to determine if it meets regulatory standards and if it's ethically sound. Consideration is given to the study's design, to the risk-benefit ratio that has been identified, how confidentiality will be maintained, and the methods for recruiting subjects and obtaining subjects' informed consent. Confidentiality protections often include maintaining research data in a locked storage area and identifying the patient in published articles by number or by pseudonym only. The privacy rule governs the PHI that is collected and used in the research environment. HIPAA offers two alternatives to researchers who are interested in collecting and using data about human subjects without undergoing an IRB review of the protocol's provision of the issues of use, authorizations, and waiver. The first alternative, often referred to as HIPAA Safe Harbor provision, allows the use of de-identified data, which refers to the data with all identifiers removed so that no one can reasonably identify the patient based on what remains. The second alternative allows researchers to utilize a limited data set. A limited data set is a form of data in which direct identifiers have been removed. Other data, such as city, state, zip, and dates of service, birth, or death, all remain. A list of the direct identifiers that must be excluded or removed can be found in the textbook, and it includes name, address, phone number, fax, email, social security number, health record number, beneficiary number, account number, biometric identifiers, vehicle license plate numbers or identifications, as well as others. Any health information manager or director whose institution is involved with medical research that involves humans should ensure that all requests for access to health information from investigators have the prior approval of the IRB. A request for access to patient-specific health information for research purposes that has not been previously approved by either an IRB if a human is involved or a health record committee if a retrospective review is called for, must be treated with great care. Unless patient consent has been given or patient identifying information has been removed or concealed, the health professional should not grant the researcher access to the information sought. In addition, health information managers and directors should consider including with any information release a written statement prohibiting the redisclosure without the institution's prior consent. Almost all providers has at one time or another contracted with a business associate to conduct its business. In the process of doing so, certain patient-specific health information may have been disclosed to the business associate. Until recently, access to and protection of this information by the business associate was subject only to the provisions contained in the contractual agreements between the parties and not to statute, rule, or regulation. With the HIPAA privacy rule and passage of the ARRA and the provisions of the high-tech HIPAA Omnibus Final Rule reconciling provisions of HIPAA and ARRA access to and protection of that information by the business associate has now come under national regulation and statute. Under HIPAA's privacy rule, a business associate is defined as the one who performs or assists in performing a function or activity that's involving the use or disclosure of individually identifiable health information on behalf of a covered entity. A business associate is not a member of the healthcare provider's workforce, such as an employee, trainee, or volunteer. The services provided by a business associate may be health-related, including billing, claims processing, data analysis, utilization review, quality assurance, or non-health related, which include legal, actuarial, accounting, consulting, or management practices. Written agreement must establish the permitted uses and disclosures of patient-specific health information by the business associate and indicate that the business associate may not use or disclose the information other than as expressly permitted or required by the agreement. The agreement should require the business associate to use appropriate safeguards to prevent unauthorized use of the information and a mechanism under which the unauthorized use may be reported. The agreement should indicate that the business associate must make its practices, books, and records available to the Department for Health and Human Services to determine compliance with the privacy regulation and provide an accounting of the uses and disclosures made since receipt of the information. Under the ARRA requirements, providers have a duty to monitor business associates' compliance with the terms of the agreement, particularly any HIPAA provisions. If a provider becomes aware that the business associate is not complying with HIPAA, the provider may direct the business associate to conform to HIPAA or may cancel the agreement between the parties. The provider's failure to monitor the business associate in this fashion may be in violation of both the privacy rule and the ARRA if it is known of or reasonably should have known of material breaches by the business associate. For that reason, providers would be wise to include audit provisions in the agreement. Further provisions of the ARRA require business associates to notify providers of any breach of confidentiality involving the security or privacy of protected health information. The ARRA expands their duty to monitor one step further, that the business associate possesses the duty to respond to non-compliance by healthcare providers. This means that if the business associate becomes aware of non-compliance by the provider, the business associate should seek to have the provider comply with HIPAA or to cancel the agreement between the parties. This is commonly referred to as the two-way street provision. Access to patient-specific health information may also be necessary to safeguard the public's health. To prevent and lessen the occurrence of threats to public health, such as communicable diseases, virtually all states require, by either statute or regulation, reporting of certain patient-specific health information. State law requires reporting threats to public health that include communicable diseases, child abuse, injuries caused by guns or deadly weapons, and cancer. One requirement mandating disclosure of otherwise protected health information is the HIPAA privacy rule. This rule mandates the disclosure in certain circumstances, negating the need to obtain the patient's authorization before releasing information. Examples of the mandated disclosure are the following: emergencies that concern public health and safety, quality and assurance reviews by authorized authorities, instances of victims of abuse, neglect, or domestic violence, reporting adverse events, product tracking, and recalls under FDA regulations, and law enforcement's use in identifying or apprehending an escapee or a violent criminal. Adoption records are the health records of individuals placed for adoption. In almost every state, adoption records are considered confidential, and disclosure of the information contained in them may only be pursuant to legal procedures. At the core of the access to adoption records issues are two competing interests. The first, that the interest of the biological parents in placing a child for adoption, often with the promise of confidentiality, and two, the interest of the adoptee for genetic information and to satisfy curiosity about his natural identity. These competing interests have clashed in years as more and more adoptees have sought access to their adoption records, including birth records. In most states, it is required to have a court order to be able to view these documents, and health information management professionals should determine applicable laws, develop policies and procedures to address the disclosure of requests. An assumption central to the discussion so far is that the demand for access to protected health information is made to the health information professional, who in turn can decide how to address the request. All demands for access may not be legitimate. Identity theft involves the knowing transfer or use without lawful authority of the identity of another person with the intent to commit, aid, or abate any unlawful activity that constitutes a violation of federal, state, or local law. Identity theft knows no geographical, racial, gender, or age boundaries and is illegal at both federal and state law levels. Health information professionals can address the potential for identity theft of health information that's used to obtain or bill for medical services or medical goods by employing preventative measures. Preventative measures include using technology to safeguard PHI, background checks of employees' associates, redacting personal information, policies and procedures for record retention, destruction, and disposal, and access to PHI based on the need-to-know basis. Prevention measures are not only prudent actions, they are required by federal regulations. The Federal Trade Commission, the FTC, has issued what are referred to as red flag rules with which most healthcare organizations must comply. These red flag rules require providers to develop sophisticated identity theft detection programs and train their staff in the use of the programs. Components of programs are listed below and include identifying relevant red flags, detecting red flags, preventing and mitigating identity theft, updating program periodically, and administering the program. The HIM professionals must develop strategies to detect and respond to unlawful access in order to stay relevant within this field. At this time, we have completed chapters 10, Access to Health Information. I encourage everyone to take the time now to review the textbook chapter and to continue on with this week's discussion module. Please let me know if you have any questions, and I'm happy to help. Thank you.